The Democrats' desperate need for a new political constituency, given that the American body politic will no longer vote for them. So they have to replace Americans with illegal migrant third world invaders. Americans don't want that. We like America for Americans. We love our nation. We don't think it needs to be diluted by a bunch of muddy cultures and societies from around the world that don't share our values, our views of our rights, our relationship to government, and who should benefit from the resources, from the economy, from the opportunities built in America by Americans for Americans. President Donald J. Trump is right now receiving huge support from Republican attorney generals, I think 24 attorney generals around the U.S., who filed an amicus brief with the U.S. Supreme Court supporting Trump's constitutionally correct argument that birthright citizenship does not apply to the children of illegal migrant third world invaders. This is the amicus brief we're going to cover today, as well as a bunch of other stuff. It covers the birthright citizenship question from several angles that differ from previous legal arguments we've covered, so I expect you guys will find this particularly interesting. Those of you who've heard the correct legal arguments on birthright citizenship before, and of course, the many tens of thousands of you who are new here. Not bad, huh? All right, so these are like 24 attorneys general from various states, of course, Republican states, weighing in on these arguments and some arguments I haven't mentioned yet, which is why I found this brief interesting, on birthright citizenship and why it does not apply to everyone simply because they're born on American soil. Simply by itself, being born on American soil is not enough. Why the amici are interested, why the people filing this brief are interested. Recent years have seen an influx of illegal aliens. They say over 9 million. They're missing a zero. It's 90 million. 90 million illegal migrant third world invaders, overwhelming our nation's infrastructure and its capacity to assimilate. And of course, many of these illegal migrant third world invaders have no interest in assimilating. They just see America as an economic zone. That's why the Indian migrants in America send 140 billion with a B dollars a year in remunerations back to India every year out of the American economy. That's why Mexican migrants in America send $80 billion a year out of the American economy back to Mexico. They're not here to become Americans. They're not here to assimilate. They're here to mine America's economic opportunities and send the wealth out of our nation back to what they consider to be their real nations of citizenship: Mexico, India, Guatemala, wherever. Many non-citizens proceed to interior states after crossing the border illegally, and then they list a whole bunch of states, and that's why they filed the amicus. They have a grievance about this. Introduction and summary of argument. Judicial review of a president's policies should rest on sound legal analysis, not prejudgments or misunderstanding of what the law actually means. The plaintiffs, the people suing Trump to stop the executive order, and the inferior, the unelected black-robed inferior district trial courts dismissed any need for a deep dive here, casting their reading of the Fourth Amendment Citizenship Clause as settled beyond a date. Don't need to look too closely. She looks fine in all that makeup. Definitely don't go on a pool date first. The states continue. Never mind that plaintiffs' mere presence at birth rule, that's what the left wants for birthright citizenship. The only thing that matters is they were present within our borders when they were born. Mere presence at birth rule cannot be right all the time, as all agree. Because everyone agrees, for example, that the children of diplomats are not citizens, or that it is contrary to the expressed view of many of the contemporaneous court cases and commentators, including, as we saw, the senators who wrote, debated, and ratified the 14th Amendment, or that it rewards illegal behavior in a manner no drafters or ratifier of the Citizenship Clause endorsed. This is the new argument that I've not seen made before, that I haven't shared with you before. It's a very good one. I got to be honest, I hadn't thought of it. Courts have viewed the plaintiffs, the lefties, correctness as a foregone conclusion, but that is seriously mistaken. Not only is the plaintiff's conception of the citizenship clause not obvious, the text, history, and Supreme Court precedent foreclose plaintiff's mere presence reading of the citizenship clause. Contrary to plaintiff's thin historical arguments, contemporaneous sources instead support what common sense suggests. Conferring U.S. citizenship requires a more meaningful connection than mere presence by happenstance or illegality by being a transient visitor to the U.S. or being an illegal migrant third world invader. That greater connection, more meaningful connection, originalist evidence repeatedly instructs was parental domicile, the permanent residence of the parents. And here they refer to Wong Kim Ark, the fact that Wong Kim Ark's parents were permanent resident aliens. Plaintiffs and the courts below overread that decision to reach their preferred mere presence rule, that it holds for just Solly, that mere presence isn't enough. But in reality, Wong Kim Ark cuts against them because it applies to the facts of the case. They were legally present and permanent resident aliens, not the parents of Wong Kim Ark. They were not transient visitors. They were not illegal invaders. Meanwhile, the plaintiffs erroneously rely on political branch practice, long post-stating ratification and ignoring this Supreme Court's immigration precedents, which further cuts against a mere presence rule. So what they're talking about here is perhaps many of you, I know me, before I started researching this law, I genuinely, if you had asked me, I would have told you, yes, birthright citizenship means you just have to be born here. Nothing else matters. I believe that because that was the conventional wisdom. We were all taught that all our lives. It wasn't until I read the actual law, read the history of the amendment, read these Supreme Court decisions like Wong Kim Ark, that I realized that conventional wisdom is simply not what the law is. We've all been pretending, acting as if birthright citizenship was something it was not. That doesn't make it the law. The states, writing this amicus brief, also write to reiterate the importance of holding litigants to the stringent requirements attending facial challenges, evolving litigation strategies after CASA, meaning you can't have universal injunctions, reinforce the need for dogged adherence to exacting tests for facial challenges. That gets a little technical. At the very least, the court should limit relief to any unconstitutional aspects and applications of the executive order if it would be wrongly applied on individual cases rather than simply ruling that the executive order in its entirety is bad law. Argument: the plaintiff's mere presence argument has serious merits flaws. The plaintiffs, the birthright citizenship generalists, would have us all believe that this is an easy case for their side. It's so obvious. It's so obvious. You see that a lot in the media reporting. Well, we all know what birthright citizenship means. It means you just have to be born here. Just like I thought, just like many of you may have thought. It just happens to not be the actual law. The plaintiff's briefing below calls the government's position, Trump's position, fringe and flatly contrary to the 14th Amendment and plainly unconstitutional. It even accuses President Trump of seeking to impose a modern version of Dred Scott being the contemptible case that held that freed slaves could not be U.S. citizens. But that puffery, I love that word, puffery, cannot cure the glaring deficiencies in their legal arguments. Examining the relevant text, the history, as we just did, and precedent, the plaintiff's mere presence position is anything but a foregone conclusion. Start with a few broader points that most accept. First, the 14th Amendment aimed to constitutionally engraft the protections of the Civil Rights Act of 1866. So let me provide a little context here. The federal government already had a law that had essentially the same language as the 14th Amendment with the same purpose. So the purpose of the 14th Amendment was to provide citizenship to freed black slaves. Remember, the Civil War had just ended. The North just won. And we had all these freed black slaves. And they were literally stateless. They had no nation. they had no nationality because Dred Scott had said, well, they can't be American citizens. And they were born in America, not anywhere else. They were born to people who were in America. So it wasn't like their parents were born elsewhere to some other sovereign. So to solve the problem, prevent us from having millions of stateless freed black slaves, the federal government said, all right, we're going to pass a statute, the Civil Rights Act of 1866, that says here, all persons born in the United States and not subject to any foreign power are hereby declared to be citizens of the U.S., no matter their race or color, and without regard to any previous conditions of slavery and involuntary servitude. Pretty clear purpose, right? To provide a state nationality to freed black slaves. The concern, however, was that a statute can easily be repealed by a later Congress. And they were concerned that a later Congress might be controlled by the Democrats, by the South, the southern states, and they would repeal this and strip all these freed black slaves of their nationality. So they decided that instead of just leaving it as a statute, they would make it a constitutional amendment, which is much harder to repeal. The understanding, of course, is that the constitutional amendment, the 14th Amendment, Birthright Citizenship Clause, should be understood in the context of the statute it was looking to engraft into the Constitution itself. Given their close relationship, the preliminary statute and the constitutional amendment that followed, that statute's history and ordinary public meaning have long been understood to bear on the interpretation of the 14th Amendment Citizenship Clause. Second, there is near universal consensus that both the Citizenship Clause of the 14th Amendment and the Civil Rights Act of 1866 sought to overturn the Supreme Court's odious holding in Dred Scott, which treated U.S.-born descendants of slaves as property rather than persons entitled to U.S. citizenship. The provisions also sought to redress the systematic denial of civil rights to freed slaves by prohibiting race-based discrimination in the conferral of citizenship or the provision of civil rights. But parental race or alienage is not parental residency, domicile, if they have a nationality already. That's a distinction the lower courts, the unelected black-robed inferior district trial courts, have failed to grasp, or they don't want to. Third, while the birthright citizenship generalists advocate for a mere presence rule, they must at the same time agree that their pure, just solely law of the soil, just being born on American soil, automatically grants citizenship. That does not hold in all cases. Even the plaintiffs stipulate that presence is not enough for children of Indian tribes to obtain citizenship. Today, Native Americans get citizenship through a statute, a 1924 statute that was required precisely because being born on American soil while your parents have loyalty to a different sovereign does not gain you citizenship. Exactly the issue we're dealing with here. But there is no statute that gives illegal migrants or transient visitors citizenship under similar circumstances. The children of foreign diplomats are not automatically citizens of the U.S. just for being born on American soil. The children of enemy combatants are not American citizens simply by being born on American soil. Feels a lot like, they're unlawfully present, right? Feels a lot like illegal migrants now, doesn't it? This means, the states continue, that the core question is not, as many commentators cast it, whether all persons born within the U.S. obtain citizenship. Even the plaintiffs here agree that's not right. The core question is whether born in the United States and subject to the jurisdiction thereof excludes only some unstated set of limited exceptions, like American Indians, ambassadors, enemy combatants, or provides a generally applicable rule that bars all those without meaningful residence-based ties to the United States. And that, of course, is Trump's view and the view of these attorneys general. Fourth, the immigration restrictions as we know them today did not arise until the early 1880s, after the Citizenship Clause ratification right after the Civil War, 20 years prior. There is thus no contemporaneous discussion among the men who wrote and debated and ratified the 14th Amendment. There's no contemporaneous discussion supporting the plaintiff's maximalist position, applying the citizenship clause to children whose parents are present in the U.S. unlawfully and after evading detection. And if rewarding parental illegality had come up with the men who passed the 14th Amendment, and this is the new argument I've not previously discussed with you, so pay attention here. If rewarding parental illegality, in other words, giving citizenship to the children of parents who broke the law to get into the U.S., rewarding them with their children having U.S. citizenship, if rewarding parental illegality had come up among the men ratifying the 14th Amendment, doing that would have violated the deep and firm legal rule ex turpi causa non oritur actio, which prohibited enforcing illegal contracts or rewarding illegal acts. In essence, this means you're not permitted to benefit from having committed an unlawful act. To sum up then, plaintiff's first principles position is that a provision that, one, aimed to confer citizenship on freed slaves, so they're framing here the birthright citizenship people's argument, that it applies to everybody. Their argument is that the 14th Amendment provision, the purpose of which was to confer citizenship on freed slaves, that does not address non-residents or invaders, nevertheless binds the Article 2 executive branch to automatically confer citizenship in most, but not all, not to ambassadors' children, cases in a manner rewarding those who illegally enter the country. That counterintuitive fallout should raise red flags about the implausibility of the plaintiff's interpretation. And as it turns out, the plaintiff's mere presence position is textually, historically, and presidentially challenged.